Good morning. My name is Gregory Ivey. I'm the Associate Director of the Underwood Law Library at Southern Methodist University. I want to welcome all of you to the session entitled First Day of Law School, Socratic Method Tutorial. I particularly want to extend a welcome to those of you who are visiting from the West Coast and who may be only now waking up. I hope you can stay that way throughout this presentation. Before we begin, I'd like to obtain some sense of our group here. With those of you who consider yourselves mostly faculty, please raise your hand. Guys, it looks like 50% or maybe a little bit more. Those of you who are mainly librarians, if you would raise your hand. Looks like, the other 30 or 40%. And those of you who are mainly technical people, if you would raise your hand. So somehow I got the percentages off because that obviously is more than 100% if you added all those together. Well, thank you very much for coming. I want to tell you that this session is the first public announcement of the First Day of Law School tutorial. There's not even a link on our website to the tutorial yet, but there will be on Monday. If you've read the session description, you'll know that the purpose of this tutorial is to prepare prospective law students for their first day of law school and, of course, beyond. Those of you who have attended law school know very well that new law school students tend to exhibit what might be called deer in the headlights behavior. They're rather overwhelmed and confused by the classroom process. And really all this comes down to the fact that they tend not to understand the Socratic method of classroom teaching. Unfortunately, the confusion on the part of the students results in a great deal of stress on their part in many cases, but also it hinders their learning process. We want to help students to understand the objectives behind the Socratic method at the earliest possible date so they can benefit from classroom discussions. And of course, we also want to lessen their stress. I think almost all of you know that there are already a number of materials out there to help students prepare for law school. There are dozens and dozens of books or manuals that talk about the law school experience. They cover things such as how to study, how to brief a case, how to take notes in class, how to prepare outlines, how to take exams, and of course, how to cope with stress in law school. I think probably all law schools, if not all, nearly all law schools have a 1L orientation session at which students are talked to about classroom discussion. They're explained the Socratic method and how it's supposed to work. There may be an example class, an example use of the Socratic method. But we know from experience that when the students actually show up for class, that a large percentage of the students still don't appreciate the objectives behind the Socratic method, and they are a bit overwhelmed, to say the least. Well, what sort of things do prospective students know about law school teaching? Obviously, students come to law school with certain preconceived notions. They've seen TV programs about law school. They've seen movies about law school. They've talked to friends who are law students or who are lawyers. Certainly, new law students know that law school classroom discussion will be different from anything that they've encountered before. They certainly understand from movies and TV that law school classes will be intimidating. They also understand that the whole process is somehow part of becoming a lawyer, part of learning to think like a lawyer. But what students tend not to understand is that the principal difference between law school teaching and undergraduate teaching is the use of the Socratic method. And they certainly don't understand the justifications behind the Socratic method. Well, it looks like most of you, in fact, clearly most of you know quite a bit probably already about the Socratic method. So I'm not going to say much about it except to say that it is the method of classroom teaching commonly employed in law school classes, particularly during first-year classes. A lot of the upper level classes are not taught with the Socratic method, but many of the first-year classes are. Socrates is obviously the eponym. In this case, he supposedly used this method. Typically, in the Socratic method, the professor will assign readings, usually cases, and the class discussion will usually focus on the cases that were assigned. The professor usually will begin the discussion by asking the student a general question, and then will follow up that general question with more complicated questions and perhaps more conceptual questions. The follow-up questions many times are based upon modified facts, and then the students are required to analyze issues in light of those modified facts. Of course, the emphasis is not on the student getting the correct answer. That's not the point at all. The emphasis really is on in-depth analysis on the part of the student. Well, why the Socratic method? Most of you already know that the Socratic Method was introduced into legal education in the 1870s by professors at Harvard, most namely Christopher Columbus Langdell, who was the dean at the Harvard Law School back then. He believed that the way to study the law was through the case method, which involved reading cases rather than reading secondary materials such as treatises. And Langdell felt that the case method was the scientific approach to studying law. Well, the Socratic method of teaching was adopted by law schools throughout the country in the years that followed, and even to today, the rhetorical devices of the Socratic method are used very heavily in the U.S. legal culture today. Well, what is different about the Socratic method that is different perhaps from the lecture method, and why is it so confusing to students? But I think this all boils down to the fact that there really is no direct or obvious connection between or among reading the assignment, participating in class discussion, and performance on the final exam. Most undergraduates pretty much have a sense that if they'll do the assigned reading, go to class, that they should be able to achieve a certain level on the final exam. All of a sudden, law students find themselves in a different situation where then they do the reading, then they go to class, but doing those two things does not necessarily guarantee a predictable result on the final exam, and that's something that's very different for those students. There's also the element of hide the ball, at least that's the phrase used to describe the situation where the professor asks questions but doesn't necessarily provide answers, and so students leave without necessarily learning additional law. Again, the focus is on the process rather than on conveying information. One reason we might want to address using the Socratic method online at this point is because of the fact that we're all pondering legal education by distance learning right now. Those of you who are familiar with the ABA teaching guidelines know that those guidelines require interactivity between the professor and the students. The only way to have such an interactivity in a distance education setting, at this point at least, would be by having video conferencing equipment. And I should add that it would really require a rather high-end video conferencing system to achieve the sort of result that you would want. At this point, the high-end video conferencing systems are somewhat rare and certainly expensive. And incidentally, I want to say that this tutorial will in no way meet the ABA guidelines requiring interactivity, and we're not saying that it would. Well, what can an internet tutorial in the Socratic method offer? Well, we're hoping that it will simulate the give and take of live interaction in a classroom. One of the most important elements of classroom discussion in law schools would be a nonlinear presentation. The professor asks questions and leads the student down a certain path, but the path isn't always predictable in advance. And in any event, the approach ends up always being nonlinear, and that's something that would be very hard to achieve in a book. So we're hoping to achieve something at least that would approach what you would find in a real law school setting. Well, how does the tutorial work? Well, just like in a real class, the student has the opportunity to read a case. The student can either then brief the case or read a brief that we supply, and then the student will try to respond to professor's questions. And just like in a real class, the student can, if they want to, show up unprepared. One of the great things about an online tutorial such as this is that the professor's thoughts are at last exposed. One of the things that's most confusing to students is that when a professor asks a question, the student doesn't always know why the professor asked that question. And when the student provides an answer, the student rarely knows what the professor thinks of that answer. So this is a great opportunity for students to understand why the professor is asking certain questions and what the professor thinks of answers. Let me tell you just a little bit about how this tutorial was created, and then we'll look at an example of the tutorial. Jane Wynn, who is a professor at the SMU School of Law and also a member of the CALI Board of Directors, conceived of this tutorial probably about 5 years ago. She completed a grant application along with some of the rest of us when we applied for a $1 million technology grant from the Hillcrest Foundation. And as part of that grant proposal, she included a proposal to develop this online tutorial. We did receive the grant, so Jane dragooned 6 1L faculty members into preparing tutorials based upon 6 traditional law school classes. One of those faculty members was supposed to develop a prototype. The faculty member who was assigned the responsibility of developing the prototype unfortunately broke his arm and had a rather severe injury and never got around to preparing the initial prototype. So another faculty member was asked to prepare the prototype. She went into a rather difficult divorce situation, never got around to preparing the prototype. So as is typical, the curse of the mummy came into play, I'm sorry to say. 2 years passed until finally some templates were developed, but unfortunately the template kept changing. So what ultimately happened was many of the professors began to design their own tutorials, and of course they were all completely inconsistent with the rest of them. Jane Wynn hired a Korean SJD student at the law school who was a talented web designer to actually create the interface. She helped them, and they worked very hard to come up with an interface that was something that they thought was attractive and very usable. And then a law student who was on the law review was hired to edit the scripts that were prepared by the teachers, and then those scripts were ultimately incorporated in the tutorial. And then, of course, a great deal of testing was involved as well. So I want to be clear, I was not actually involved in the preparation of the tutorial. It was designed and conceived by Jane Wynn. 6 1L faculty members prepared each of the tutorials. A law review editor did the editing, and then a graduate law student did the HTML and the other web work. How will this tutorial be used? Well, we are going to let all of our admitted students know about the tutorial so they can begin to get some sense of what classroom discussion in law school is all about. We probably will use it to recruit prospective students. And of course, we're going to make it available to the world so that any other persons who are interested in law school, might be planning to attend law school, will be able to use it as well. So at this point, I want to introduce you to the tutorial. This is the URL, which at this point is not available on our law school webpage. Let me bring it back up. But we will make it available on the webpage on Monday. So if you'd like to copy down the URL now, I'll give you another opportunity at the end of class. Okay, this is the first page of the tutorial. There are really only 3 things you can do from this page. First of all, visit the welcome screen. And this is it. It mainly consists of a welcome from Jane Wynn. It tells you about the Socratic Method and the purpose of this tutorial. Then there is another link that is really helpful information that tells you how to use this tutorial, provides sample screens, and if I say so myself, I do think the tutorial is very user-friendly and should require very little help. Then from this menu, you can choose 6 different classes which students can attend. I'm going to demo the criminal law tutorial this morning, which begins on the screen. Now, I know there's nothing worse than having someone read information off a screen to you, but unfortunately, I know that the font used here is going to be too small for most of you in the back 2 or 3 rows to read. So some of this I will have to read to you. There's a link here to the webpage of Professor Bridge, who prepared the criminal law tutorial. This webpage is on the Dedman School of Law website. It gives us photograph, obviously, and biographical information. So if the person is completing the tutorial want to know more about the preparer of the tutorial, they can get that information. And here is the introduction he prepared, and I'll read at least part of it to you. These questions are not necessarily in order. Class discussion is not linear. I might not ask all these questions in class, but the student would be thinking about them. Because Keeler appears very early in most case books, I would ask basic questions to judge how well students are reading cases and to encourage them to read even more carefully. After the first few weeks of class, I would take for granted that students searched for the definition of every word or phrase they did not understand. I would also assume that they knew the procedural history of a case. I never assume command of the facts. At this point, you can click on the tab to read a case. In this case, Professor Bridge has edited down the Keeler versus Superior Court decision to about 75% of what it is in the original reporter. So this is actually a much lengthier case than you find in the other tutorials. The next tab takes you to a brief. The other briefs provided in the tutorials tend to be more traditional briefs where the issue is phrased, the rule of law is identified, there's then the application of the rule of law to the facts, and then there's a conclusion. In this case, Professor Bridge takes a more conceptual approach and says, at its simplest level, CALI is about the born alive rule, its derivation and current force. No teacher of criminal law would use CALI or any other case or any other assigned reading to establish this point. At the next level, CALI is about sources of criminal law and the interplay of common law and statute. It leads to consideration of the meaning of the phrase common law. On a yet more sophisticated level, CALI is about judicial method, i.e., how courts need the raw material of the law to answer an issue. Then the third tab, of course, is going to class. Now, I'm not going to run all the way through this tutorial. We'll skip some of the questions. But you'll notice here on the left-hand side that there are 8 questions in this tutorial. Some of the other tutorials have only 3 questions, for example. In Professor Bridges' tutorial, some of these questions even have subparts. Let's begin, then, with question 1. What is the name of the case? The student can, if they want to, click on what is referred to here as a thought bubble that reveals what the professor is thinking when he or she asks this question. And in this case, the professor is asking, now you're thinking, hey, law school is easy. Just wait a few moments. Well, in this case, the student can't go wrong because this is a multiple choice question, but there's only one answer here. So if you click on answer A, the professor replies right and follows up with the question, who is CALI? And then another thought bubble comes up, which the student could click on at this time. It's interesting that during the testing of this particular tutorial on various students, including undergraduate students and law students, the undergraduate students almost always went directly to the thought bubble or the hint, whereas the law students went directly to the answers and tried to answer the questions themselves. So perhaps the law students felt more confident in their understanding of the legal issues, or perhaps they were just accustomed to working harder and not needing the hints. Who is CALI? If you click on the thought bubble, in this case, the professor says, I know you're thinking, hey, this professor is easier than everyone told me. If you close that, you can then select various answers. Answer A brings up the response from the professor. Incorrect. You do not want to say the killer for 2 reasons. 1, there has been no trial yet, thus no conviction. 2, the answer in the case is whether Robert CALI is the killer of a human being. So not only do you select the answer, but then you get a reply from the professors telling you why the answer was a good or not so good answer. Another option, answer B, is CALI is the defendant. Again, incorrect. The professor's reply is he is the defendant in a criminal case, but the case you read involves a proceeding of for writ of prohibition, so something is missing from your answer. Going back to the question, I'll select the correct answer, which is question D, answer D. Professor's reply is correct. Yes, either answer alone is incorrect. Petitioner is less incorrect than defendant. Then there is a follow-up question. Now, who is superior court? If you click on the thought bubble, warning, do not answer the prosecution. That leads to an embarrassing comment about your junior high civics school teacher, high school civics teacher, and 3 branches of government. Okay, the answer is the judge in the case. The professor's reply correct. Right now to the next question, so we go on to question 2. Why is CALI suing the superior court? Again, the thought bubble. Finally, we all think, and the time passes much more gracefully for the students than for the teacher, especially the student standing to answer these questions. So why is CALI suing the superior court? Well, the answer, CALI wants the Supreme Court to order the judge to dismiss the charge of murder. The professor's reply, right, carry on. Question 3, what does en banc mean? Choose the better answer. The thought bubble, and now you're thinking, wait, isn't this course criminal law? What do I know about banking law or about appellate procedure? But every case is about procedure. You have to know who you're talking to in what context before you know what to say. Answer A would be, the case doesn't tell us, but if we click on the hint is that the answer is not in the reading assignment, which is something that the new law students are not accustomed to. Answer B, which, by the way, let me read answer B to you, usually spelled in Bach, it means on the bench, and that the entire court or a substantial portion of it is sitting on the case, not just a panel, usually of 3 or 5. If you clicked on hint, the professor would say, I see you've recognized that you may need some knowledge that is not conveniently available in your casebook, and you took the initiative to find it. Moving on to question 4, what is the proceeding? Thought bubble. Remember what the teacher thought, but did not say about the importance of context. Technically, this is not a criminal case anymore. It is a civil suit against the Superior Court. Just to make it more confusing, the Superior Court is a court inferior to the Supreme Court. Answer A, the proceeding, which, by the way, let me read the answer. The proceeding is a petition for a writ of prohibition. Professor's reply, yes, then follows up with the question, what is a prohibition? Thought bubble, unfair. The answer to that question isn't in the reading assignment. Yes, it was, if you understand the reading assignment to include understanding the words in it. Find the law dictionary your great aunt gave you for your birthday. It's probably holding one end of the bookcase. The answer, an order from the Superior Court to an inferior court, again, here the inferior court is the Supreme Court. Okay, as you can see, the questions are getting more difficult. The next question is, and what does that mean in this case? The thought bubble, time to apply the abstract definition to the concrete case. Here the answer, that Keeler is asking the Supreme Court of California to forbid the Superior Court from conducting a trial on the information charging Keeler with the murder of baby girl Vaughn. Question 5, what are the facts? And there's an important footnote here that reads, question 5 is composed of a series of the professor's interjectory questions and the student's recitations to find out the facts in this case. If you click on the thought bubble, it says, at this point, a student usually thinks, finally, a question I can handle. This was in the reading, and they're in my brief of the case, right from page 1, column 1, line 15 of the case, down through page 2, column 1, line 6. Literally, any word you say will draw an interrupting, usually, or follow-up question, so just leap in and have fun. Professor, call her Mr. Keeler, and Teresa Keeler, call her Ms., obtained an interlocutory decree of divorce on September 27, 1968. Thought bubble. Call petitioner Mr. Keeler and Teresa Keeler, Ms. Keeler. If you say petitioner, I interrupt to ask why you refer to Mr. Keeler as petitioner. It usually means you're copying the facts rather than digesting them. Question, what is an interlocutory decree of divorce? Thought bubble. Now it's family law. I usually interrupt to ask why the student includes the date of the divorce. It may be relevant to the Keeler's level of guilt or punishment, depending upon when the fetus was conceived. It is irrelevant to the issue in this case. Okay, continuing then with question 6. What is the procedural history of the case? Thought bubble. It is important for students to seize quickly the importance of the procedural posture of the question in every situation. The answer in this case, Keeler was prosecuted by information for murder of the fetus, willful infliction of traumatic injury upon his wife, and assault of Mrs. Keeler by means of force likely to produce great bodily injury. He moved to set aside the information for lack of probable cause, and the trial court denied it. Keeler now seeks a writ of prohibition. You click on question or answer A, professor's reply, good, on to the next question. What is the statute? Answer A is Penal Code 187. Answer B, murder is the unlawful killing of a human being with malice aforethought. She selected answer B. Professor's reply, correct. Yes, we will spend weeks on homicide later in the semester, so now we discuss only briefly the elements of murder in order to show elemental analysis of a criminal offense. The statute provides the elements of murder, unlawful killing of a human being with malice aforethought. And then finally, going on to question 8, what is the issue? Again, the thought bubble. Especially in the early weeks of the first year of law school, answering this question can take a long time. It is important to include every important question in each issue, but only the important questions. I discuss phrasing issues and the whether formula as stating the issue of the case. In this case, I'll go ahead and select the correct answer, which is answer D. Professors reply, very good. This is one of the ways of correctly stating the issue in this case. We'll continue with this case next time. Class dismissed. And then the thought bubble, which is, students are often surprised to find how much time and effort discussing a case involves. The first class shows students that analyzing a case involves attention to detail and thinking deeply beyond the words on the page. This case could take anywhere from 3 days to 3 weeks to cover, depending on the depth of in-class analysis and the pace of the questions and answers. Okay, as I indicated to you earlier, there are 6 other tutorials. There's one on civil procedure, one on constitutional law, one on contracts, one on property, and then one on torts. It's interesting when you review the tutorials that each one of them tends to mirror the own professor's classroom style. I selected the criminal tutorial to demo just because this professor is one who's very devoted to the Socratic Method, and I think his tutorial does a very good job of demonstrating at least the essence of the Socratic Method. I want to tell you that the original plan for these tutorials included audio and video. The plan was that the professors would be videoed at least responding to questions, and I should say responding to answers, and telling why those answers were or were not the best answers in each case. Using the grant funds, we actually purchased a rather expensive digital video camera, and we actually videoed at least some of the professors reading their questions and reading their answers. What we discovered was, first of all, that although professors may excel in the classroom setting, they appear many times rather wooden on video. So that was not a compelling reason, at least, for having the professors on video. Also, we wanted to avoid any technical issues involved with streaming audio and video. We have no experience at SMU streaming audio and video. Obviously, we can learn how to do it, but we knew that certain requests for help and technical assistance would ultimately arise from our users, and we wanted to avoid that if at all possible. While the audio and video certainly would have made this a more glitzy website, we also didn't think that this would add anything to the learning experience. The essence of the Socratic Method is pretty much conveyed through the written word as well. It's interesting that John Mayer had advised Jane Wynn against trying to stream audio and video in the context of this tutorial, but she brought it up to him about 5 years ago. And sure enough, at least Jane Wynn thinks that he was right in his assessment. Also, originally we had planned, or at least Jane Wynn had planned, for more follow-up questions to each of the answers. That is, when you selected an answer, you would then be led to another question, and then a follow-up question from there. And so no matter which answer you would choose, a different follow-up question or series of follow-up questions would arise. Obviously, if you multiplied out 4 answers times 4 questions for each answer times 4 follow-up questions for each follow-up answer, you start ending up with a huge number of questions, of thought bubbles, of hints, etc. Also, the logical structure of the branching that would be required to lead people throughout this logical analysis through all the follow-up questions turned out to be more complicated than what they wanted to deal with. But had they done that, had they added the audio and video and the follow-up questions, obviously that would have done a little bit more to capture the essence of the Socratic Method. Well, we hope that you will take the time to evaluate the online tutorial yourself. Again, that's the URL for the tutorial. And if you find it worthy, we also hope that you will recommend it to your prospective students and perhaps your current students as well. Does anybody have any questions? I was not involved in the tutorial itself, and as I indicated, Jane Wynn is in Oxford right now, so she was not able to be here. But I'll be happy to try to entertain any questions if anybody has any. Okay? Well, if not, yes, sir.
What has been the reaction among students to it at SMU?
Well, the only students that have seen it were those who tried to test it.
Okay.
And although we tried to test it against a variety of students, that is 1Ls, 2Ls, 3Ls, etc., the reaction has been positive. Obviously, it's difficult to get students to focus on this for any length of time and provide insightful observation. But from the testing that we did with the students, the tutorial was continually revised because they did offer insight, at least that they thought it was valuable, and something that if they would have taken the time to fully explore before they came to law school, they generally indicated they thought it would be helpful in understanding the Socratic method at an earlier point. But if you race through the tutorial and really don't take time to analyze the thought bubbles and the hints and try to understand the significance, obviously you're not going to get as much out of it as you might otherwise. And that's what we found out from testing as well. Yes, sir.
Any plans to expand it beyond these initial 6 courses, or are you looking at it as basically a first-year tutorial and letting go of that?
That is up to Jane Wren at this point, and actually I was a little bit surprised by the answer that she gave me approximately 3 weeks ago, which was that at this point she looked at this as a published book. And she had other projects that she had to move on to, etc. But I will tell you, we're continuing to edit these scripts and so forth even now. In fact, there was a lot of editing going on earlier this week. So I don't know that there are any plans to extend it to other courses. In fact, I know that there are no plans to do that at this time, but that doesn't mean that it won't happen. Any other questions? Yes, sir.
Do you envision this thing as something useful primarily for people considering whether to go to law school, or something useful for someone who is in law school and is struggling with the Socratic method?
Both of the above and other things besides. The primary group that we're going to target this to is going to be our own admitted students, so that they can take a look at the tutorial, and when they arrive on their first day, they'll have some better idea of how classroom discussion proceeds. That's the primary group. But I would think a 1L struggling in the first few weeks or months of law school would be interested in this as well, because I think once they go to a classroom and participate in a classroom discussion, they'll understand better what the implications of all of this are than perhaps before they arrive at their first day. But for that matter, it's available to the world. It's available to undergraduates who are thinking about going to law school, all the above. Okay, any other questions? Yes, sir.
Any plans to financially profit from this at all, or is this going to be freeware?
It's absolutely freeware. I'm not going to tell you that there's not a certain element of marketing involved in this. I mean, obviously, we want to attract whatever students we can to the SMU School of Law, and that's probably one reason it's out there, but that's not the chief reason. Yes, sir.
I didn't see a feedback form or on the tutorial website. Is there? How are you going to solicit feedback from the students?
There is a link that you can use to email the webmaster. What I don't remember is whether or not there is a link that invites feedback. Obviously, there's Jane Wren's email address as well, but that's a very good point that we should have a prominent link inviting feedback to the tutorial. Thank you very much. And as you take a look at this tutorial, which I hope you will do, feel free. In fact, I want to encourage you to email Jane Wren about this if you have any suggestions. Okay, any other questions? Yes, sir.
What criticisms from your own faculty have you had?
Well, because the tutorial is not out there yet, I have to say I'm not aware of any criticisms. That doesn't mean that Jane Wren has not received some. But I do think it's interesting that the 1L professor who is most devoted, perhaps, to the Socratic method, Professor Bill Bridge, is one of the ones who did prepare one of the tutorials. And I think that indicates, obviously, he's devoted to the Socratic method and yet still approves of the tutorial. I wish I had more information on that, but I've certainly not heard any criticism or any concern voiced at this time.
How many of your faculty have used your preview?
I would estimate probably 10 to 15 out of a total faculty of 40. Okay. Any other questions? Okay, well, thank you very much for coming.